Hypocrisy.
Hey, what's up, guys? Welcome to Law Splaining the Interwebs. I am your host, Nick Ricada of Ricada Law, a small law firm in central Minnesota. Today with me is returning champion, my good friend Andrew Branca. How you doing, man?
I am doing awesome, man. Life is good. Life is good.
I love to hear that in the gayest way possible.
Life is good in the least gay way possible.
Okay, so there's an imbalance already on the stream, and I'm feeling a bad energy. No, I'm just kidding. Guys, today we're going to do something hopefully fun. We're going to listen to the oral arguments for the Supreme Court that were presented earlier today in the Trump v. Anderson case. This is the case coming right out of Colorado, where the Colorado Supreme Court has decided that Donald Trump can't be listed as a presidential candidate because #reasons. They determined under the 14th Amendment, Section 3, that he is not eligible as he engaged in or supported an insurrection. And that gave them a big erection. Because, I mean, think about it for just a second. Like, the Supreme Court of Colorado hamstrings one of the presidential candidates who's likely to win and has been president already. That's a big move. That's a power play, man. I would be turgid for a week.
So, and by the way, they've been this way for quite some time. So Colorado, for people who don't know, Colorado 10 or 20 years ago was a vastly different state than it is today. It used to have a split legislature between Democrats and Republicans, but it's been completely Californicated since. So the Democrats have a supermajority in the legislature. They have the governor's office. They have the Colorado Supreme Court by a majority. And the Colorado Supreme Court does stuff like this, to give an example. So years ago, the Colorado legislature passed what we call a firearms preemption law, meaning that there's one set of gun laws for the whole state. Every city can't make up its own gun laws, so you never know what gun laws are in effect as you travel around the state. Yep. One set of gun laws for the whole state. And then Denver and Boulder decided they just wanted to pass an assault weapons ban. And this was pursued all the way up to the Colorado Supreme Court. And the Colorado Supreme Court says, well, we can see there where the legislature says that's not allowed, but it feels good to us. So we're just going to let it happen.
And then what do? Then you have to kick it up to the U.S. Supreme Court and hope that they take the case and want to intervene in a specific state in that specific way. And then also, by extension, intervene in every state, many of whom have not asked about this question. And that's the scary thing about Supreme Courts. But this case, in my opinion, is a little bit different nature. This one, I love that. Of course, the U.S. Supreme Court had to take it up because what Colorado did was take an 1867, I think, amendment that has never been used against any president and decided how to use it. No laws have been written about disqualifying a president, even though in Article 5 or Section 5 of the amendment, it says that Congress shall make laws necessary to enforce the provisions of this amendment. There's no laws about it in regards to this. They just said, well,
the whole purpose of the amendment was to constrain states' rights.
Yes.
Not to give states more authority, but to limit their authority.
Right. Because if people don't know, this is probably the main Reconstruction Amendment that revolves around or involves how the country operates. And it really did change the application of the Constitution because the 14th Amendment would go on to allow the Supreme Court to incorporate the Bill of Rights and apply it to states, cities, municipalities, all levels of government. It only applied to the federal government. It only restrained federal government at first. So you could, if your state constitution allowed, constrain free speech, gun rights. The state could quarter a militia in your house, stuff like that. Now, most of them mirrored the U.S. Constitution, but those protections didn't extend unless the state independently protected them up until the 14th Amendment. And more importantly, a case actually applying the 14th Amendment to that provision. So this has never been tested. This has never been applied. There's a case of first impression that involves the very highest use case of it. And my question for you, Andrew, is do you think that this amendment in any way applies to a former president or a presidential candidate in its two categories of former office holders and future office holders?
Well, I think there's a lot of a lot of important questions in this case. I would say no to all of those because I don't think the U.S. President POTUS is an officer within the context of this amendment. But even which I think is where SCOTUS is focused today, basically. But also there's questions about, everyone, if you watch the media, it's all assumed like an insurrection actually occurred on January 6th, but no one has been charged with the crime of insurrection. So this is just rhetoric, this insurrection talk that's been happening. So it's all nonsense. It's all political fabrication and propaganda.
Of course. And the Colorado Supreme Court's finding of Trump engaging in an insurrection is based on the district court in Colorado finding from the January 6th special committee, which should have been entirely hearsay document from the January 6th committee report, that Trump engaged in an insurrection to the evidentiary standard of a civil suit.
A lot of due process there, huh?
Yeah, to the evidentiary standard of a civil suit, which is basically by a preponderance of the evidence, which means 51% or more, whereas typically to be convicted of insurrection, you would need beyond a reasonable doubt. So there's no clearly applicable standard for criminal application, and yet this amendment is based on a criminal concept, which is
and even by a preponderance of the evidence, it would be by an impartial and unbiased jury subject to voir dire, right? Not a committee of your political opponents.
Right. And then applied by a judge who just accepted it as evidence without a competing issue. I mean, that was the point. They objected to the report. It didn't get, I guess, there's no evidence to sufficiently counter the report because the only other evidence.
They lost it.
Yeah. Well, lost is a strong term. Pelosi's sitting there flipping her bean to that thing every night, all the missing video, but.
Oh, thanks for nothing, Nick.
You're welcome. That's for you. So we're going to get started on this, guys. It's 2 hours long. Each side gets about an hour to present their case. If you haven't listened to a Supreme Court oral argument before, basically an attorney for one side is going to stand up and start talking and immediately going to be interrupted by justices. We're going to ask them questions and they're going to have to tailor their responses to what the justices are asking. Now, the media makes a big deal out of the questions justices ask, and they're like, oh, this means they care about this issue or feel one way or another about this issue. But I caution people to be neutral on their assumptions about what judges mean with their questions. Just listen to the questions and what they're asking specifically, and then listen to the answers, because the media knows jack and shit about this stuff. They always misreport what justices are looking for and what they end up talking about. And in this one, I can tell you, my favorite thing I've read about this so far, I have not listened to the arguments, but my favorite thing I've read so far is that they are baffled. These experts, these analysts are baffled that all of the justices seem to be of the conclusion that a state can't disqualify a presidential candidate because it doesn't make any sense. They're baffled by this. I'll tell you, there's a YouTube asshole who said, who laid out this argument very well, why a state cannot be allowed to disqualify a president. It's insane that they could, absent a specific standard set forth by Congress as the amendment request. So we're going to start in just a second. There's a couple chats that have come in. We are going to take a break at the 1 hour mark. We'll flip to Rumble. We do have 2 sponsors for this show, so I want to make sure we get those. One will be at the Rumble flip. One will be a little 30 minutes or another hour in, and we will just go on. And we're going to try and keep this thing as short as possible. That's what she said. Let me read these things. Uriah of the House Right says, yo, Nick, have you watched the Tucker Carlson interview? I assume you mean the Tucker Carlson interview of Putin. No, I have not. No, I'm not super interested in it. I know a lot of people are. Maybe I will, but I've been busy, and my busyness doesn't usually include TV and certainly doesn't include news stories and interviews. That's just not what I watch. But no, I have not watched it. L Prince, welcome to Paralegal Status. The Hot Dog Wizard says, evening, Mr. R. Heroes live forever, but legends never die. Can you give a toast to Paul Harrell when you get a chance? A legendary gun YouTuber who is fighting terminal pancreatic cancer.
He's a great guy, Paul Harrell. Unfortunately, dying now of Cancer. Yeah, a giant in the gun community. Millions of followers on YouTube. It's been around forever. A legit good guy in the gun community. Yeah, terrible.
I am not aware of him because I'm not really aware of anybody. But let me say, if he comes from that kind of recommendation from Andrew, then I will say this: a toast to Paul Harrell, a man respected in his community, in his profession, his expertise, a man who has inspired others, led others, and educated others. May he be delivered from pain. May he be delivered into the hearts and memories of his loved ones and his fans and his friends. Cheers to him and the life he built. May we all be inspired by his success.
Salute, Paul, and your great work you've done all these years.
Cheers. Cheers. Let's see. Next, we got John Tao 263. Can I get a toast for my good friend Al, who passed away Monday night? He's lost his battle with cancer at the age of 42. That's terrifying. That's my age.
And wait till you get to my age. People are dropping like flies.
Yes, to Al, again, another person who fought cancer to a draw. May he rest in peace. May he rest free from pain, and may his family mourn his loss, but cherish his memories. Cheers. And Phantom Lord DJH07 says, well, never doubt a media expert's ability to be completely wrong. Correct. Couple more from Rumble. Randall McCollum says, I'm here for the Rackets and Branca doing oral stream. That's on Chatterbait after the show.
We'd have to get our wives to agree, I guess. That would be awkward. It's going to be pretty high super chat limit.
They'd be like, wait, you guys are going to do that? Yeah, just do it. We'll not make fun of you for the rest of your lives. Richard O Team says, Branca, if someone called you a child molester who likes to suck on little boy cock, would you sue them?
No.
You wouldn't sue them?
No, truth is the ultimate defense. I mean,
oh, Jesus Christ. God damn it. Richard O Team says, Branca, if someone called you a child molester and said you sucked a little boy's cock and kept telling everyone what was said is 100% true, how hard would you sue? Answer the question.
Yeah, I got threatened with a lawsuit just last week. I just wait for them to serve process and I take it from there. But so far, it's never happened. It's just threats.
Yeah. Well, of course, this person is trying to get you to answer the question of my lawsuit. Very dangerous.
That's a question for you.
No, he wants you to know. Or your answer, because I know the context. So therefore, he's looking for your It's a troll. Richard O Team again says, Nick, did you lie or tell Branca the truth of how you called Monty a child molester who likes to suck little boy cock and should be shot, but you caused no damage?
Sorry, I didn't know any of that.
No, I didn't talk to him about it at all. I would say that I think you've missed a couple parts of that statement, and I think you may be confused about what an opinion is. Richard O Team says, Nick, is you saying that Monty, who, quote, likes to suck little boy's cock and should be shot? I think I said probably, but that's okay. That's right.
Are they paying for these?
Yeah. I mean, they can send them all day. That's right. You said he should be shot. Is that damage by defamation per se? Well, no. It's not damage by defamation per se.
Sounds like opinion to me.
It also tells me that you don't understand defamation per se, because saying someone should be shot isn't damages. Also, defamation per se just means that the damages element of defamation doesn't have to be proved to win the suit. All of the other elements still do have to be proven, and you don't actually win damages with a per se damages, award. You have to still prove damages in the damages phase to win a judgment to get compensatory damages back. You can have per se damages, and then when you go to prove them out, you have no damage.
There's
and you
zero.
Get a nominal award of $1 or $100 or something like that. Happens all the time. But in this case, I will say no defamation has occurred, and we shall see how that goes. Next, we got Guardian Gamer says, howdy, Nick and Branca. I've decided to shift careers and get my paralegal degree. Know any good classes to supplement my legal knowledge? Man, I don't want to say this. If you're going to be a paralegal, look, I'm not going to say
Why? I mean, just be a lawyer. And if you said you want to be a lawyer, I'd also ask why? I mean, I know a lot of miserable lawyers. there
Yeah.
are people who have a calling to the law, like a calling to the priesthood. And if that's you, just be a lawyer. Just go and do it. Suffer the being of a lawyer. But if you're thinking of doing it like to make money, that's not a good plan, because the kind of talents you need to make money in the law are very similar to what you would need to make money in real estate or car sales or any other business profession.
It's literally
and the law carries a lot of baggage with it.
Yeah. Being a lawyer is being a really good salesman of yourself, and then having a whole shitload of responsibility for other people's lives put on your shoulders.
A lot of responsibility.
And it can be very, very intimidating. It can burn you out. It can do all these things. One thing I'll say, I'm not going to stop anybody from doing anything at all. I don't care.
Sure.
But if you want to be a paralegal, you really have to ask how useful paralegals are going to be as AI coming. There's questions about how useful lawyers are going to be as AI improves, but paralegals, I'm telling you, Westlaw and Bloomberg and Lexis are developing AI products that will automatically do the things paralegal do. They will generate template documents. They will file things for you at specific times. They will remind you of deadlines. Yeah. They will get things done. You'll upload it into a queue, and then that thing will just go ahead and do the state filings. That's coming soon. A good paralegal is irreplaceable, but AI is going to replace many paralegals that are not quote unquote good paralegals. And eventually lawyers are on that chopping block. So unless you are able to do what the best lawyers at the firm do, who are not the best lawyers, but they're the best whale catchers, unless you're able to do that, look at what you do and look at what you want to do with that degree. Because if you're just going, oh, I can make money or have a stable career, you may not. Just consider it very strongly.
So in my office, we use Lexis, and I get emails every day from Lexis pitching AI capable productivity levers.
Yeah. It's I use Westlaw, and they have,
because you're gay.
Well, yeah, yes, but their salesmen keep calling me and they're like, hey, we want to tell you about our new AI product that'll really help your firm. I'm like, I don't practice this way. I really just need the research tools, so I don't need all that stuff. But they're pitching it constantly. They're upgrading it. Like, they're hiring Indians faster than anyone else to type up this code, guys. This field is about to shift dramatically, and a
lot of lawyers are just going to get wiped out. So if you're doing kind of the, so I would say like 80% of the legal profession, especially in the last couple of decades, does kind of crank the handle law, where it's very kind of rote law. It's not very complicated. It's the same cases over and over again, simple divorces, straightforward bankruptcies, minor crimes. They just, clients come in, they crank, all those lawyers are going away. They're going away. Because higher level law firms will just have AI processing those cases.
Right. And it'll do it. Doesn't matter how good of a paralegal you have. The AI won't get sick, won't take days off, won't get pregnant, won't have mental health days, won't have trouble at home, won't have all of the issues that can make a very good employee into a very bad employee really quickly. So that's going to be the thing eventually. Just be cautious what kind of career you enter into, because paralegals don't have a ton of advancement opportunities. It really is a limited field. Like what's
the upside? You have to become a lawyer,
right? And that, which means you have 2 more years of school at least. And it's like any of the other subfields, like a pharmacy tech. Yeah, you can make good money as a pharmacy tech in a small town or whatever, and it's a nice job, but you don't go anywhere from there. But anyway,
I think we're really deviating to the mean. So 60 years ago in the legal profession, there was a very thin layer of lawyers, and then we just opened up the gates, and anybody could become a lawyer. And so we got a very fat layer of lawyer, but the actually good lawyers were still that thin layer at the top. And I think what AI is going to do is just remove all the 80% who aren't in that thin layer.
Yeah, the 80%. It's the top 2% of employees generate like 80% of the revenue. The next 18% generate the other 20% of the revenue, and the bottom 80% do nothing. So just be cautious when you're entering a long-term career, considering what's going on.
Especially if it's expensive.
Yeah. Yes, exactly. Okay, here we go. Kate C, aka Snake Plush Kitten, says, what is this document you talk of? The Constitution. The media makes no mention of it. L Prince, it's probably been a year since I've seen a live stream. You two are effing great. started you with Rittenhouse. Oh, thank you. Don't quit me. The Hot Dog Wizard says, why did they not use the Chewbacca defense? It's a good question. Doc Salty 96. Hey, Nick, asking for a bit of advice. I'm 27, currently studying software engineering, feeling a call back to medicine or law enforcement officer. What should I do?
Not law enforcement. In America, at least, no law enforcement. Don't do that.
Software engineering is great, but if you don't like it, I mean, medicine, it's expensive and long. It's expensive and long, man. You got to think about what you're doing. If you got a calling to it, go follow your calling and be good at it. But think why you're trying to pursue these career changes. Bad Dragonite says, chat, Nick, have you seen this thing? Nick, no, I've seen nothing, heard nothing. I exist outside of known space-time. I'm one with the void. Correct. Dudes, I don't watch TV. I don't have TV. I don't sit around watching news on YouTube. I don't ever listen to Ben Shapiro. Like, I don't know about any of this stuff. I sometimes see shit on Twitter, but it's not my interest. Unless I'm streaming about it. Richard O'Team says, I like when midlife crisis Branca with his young Disneyland wife and his bikes and Rolex laughs at anyone sending about $20 to laugh at you, Nick. I like it too, because that means you sent me.
It's a pretty good life, I got to say.
It's great. All right, here we go. We are going to start up this oral, so to speak, and then we're going to just listen. I'm not going to keep this here. I think I can keep. Tell me if you can hear this.
Case 2379.
Yes.
Okay, so we'll hear it through this, but we're going to have our face. There's nothing to see on the screen. If we need to pause it, we will. Otherwise, we're just going to go through, laugh at this stuff, listen to the arguments. If we've got a point, we'll make it. But let's go, ladies and gentlemen.
Just here to have fun.
Of course. And make fun of we'll see.
Trump versus Anderson. Mr. Mitchell.
Ooh, Mr. Mitchell.
Mr. Chief Justice, and may it please the court. The Colorado Supreme Court held that President Donald J. Trump is constitutionally disqualified from serving as president under Section 3 of the 14th Amendment. The Colorado Supreme Court's decision is wrong and should be reversed for numerous independent reasons.
Really quickly, solid start. They're wrong. Done. That's it. And that's true. Here we go.
The first reason is that President Trump is not covered by Section 3 because the president is not an officer of the United States, as that term is used throughout the Constitution.
Correct.
Officer of the United States
Yes. refers
only to appointed officials, and it does not encompass elected individuals, such
My
as
dad was an officer appointed by a president.
here from the Commissions Clause, the Impeachment Clause, and the Appointments Clause.
And also just a logical conclusion of the text where they lay out all the people that are included in this amendment. It doesn't include the president or the vice president, but it does include representatives, senators, who, if a president is an officer of the United States, it seems that a representative or a senator would be an officer of the United States in the same way. It also includes electors for president and vice president, and then officers and subordinate positions as we go down the line. And yet it doesn't include the highest offices in the land that are very specific and very public. It just doesn't make sense with the drafting in any logical way. Also, if you consider when it was drafted, there would be no reason to exclude President Lincoln or whoever his vice president was, I don't remember, from holding office subsequent to this. But there's a whole lot of reasons to exclude every other officer that's listed and every other position that's listed because they would have been in the South. And it's highly possible that the framers of the 14th Amendment, we don't know, but it's highly possible they intended this to be a one-time application of a banning through insurrection.
And this is completely normal. So even at the state level, there are elected officers, right? The state attorney general, sheriffs, there's the secretaries of state. Their removal from office is completely different than every person under them.
Yep.
So the top tier, the elected tier, is treated routinely at every level of government in a completely different way than the people who simply report to the person who was elected by the people.
Right. And the other difference between the president and the vice president than any of the other people listed, first of all, the other people listed are appointed except for officers, representatives, and electors. But all of those are elected officials confined specifically within one state, and their disqualification from holding office or acquiring office has no impact on any other state decisions. So you could say a Colorado national representative can be disqualified in Colorado, and that only affects Colorado voters. But if Colorado, or let's say actually California, were to disqualify a Democratic candidate due to insurrection by some miracle, then California would be effectively removing that Democrat candidate from the election in the entire United States based on their electoral vote count and the propensity for voting liberal. You can't say it definitely would happen, but that would be the likely outcome, and that would impact every other state's ability to vote for that candidate. That's a big problem with this whole thing. Richard O'Team says, of course, instead of spending money on a Disneyland wife and Rolex and bikes, I save money laughing at Nick.
With Nick. Get it right.
No, he saves money by laughing at me.
Oh, okay. All right.
Yeah.
Fair enough.
I always question someone like that's ability to buy those things, but I'm not one to judge. Here we go. Doc Salty says, for context, this is a guy who wanted to become paralegal. I was a hospital corpsman in the Navy before. Fiance's in med school and want something that I can take anywhere and support a family. Wait, that's not that's the software engineering guy, Medicine or Elio. Dude, can't you do software engineering anywhere? It's all going remote. So I don't know. Seems like it'd be good. And it's also a well-paying job. Me04120 says, wasn't Nick going to do a stream with Branca, writing a letter to the Colorado Public Defender's Office? Whatever happened to that? We just never got around to it.
Yeah, so the problem, folks, is Nick is super busy. I'm super busy. And we have far more opportunities for fun content than we can possibly pursue. That is one of them. I would love to do that, but we have to prioritize with new news coming in all the time. We have to pursue what's hottest. That's how you drive these kinds of businesses, and we'll see what happens.
And Andrew's not always available for late streams. And while I have intentions to stop doing as many late streams and add some day streams instead, that hasn't happened yet. I have to figure that out and find if I can put that in my schedule. Back to
if you folks haven't noticed, it's very unusual for me to be on the air at midnight Eastern time.
Yeah. Here we go.
Each of which uses officers of the United States to refer only to appointed and not elected officials. The second reason is that Section 3 cannot be used to exclude a presidential candidate from the ballot, even if that candidate is disqualified from serving as president under Section 3.
Yes.
Because Congress can lift that disability after the candidate is elected, but before he takes office.
That's not the only reason.
A state cannot exclude any candidate for federal office from the ballot on account of Section 3. And any state that does so is violating the holding of term limits by altering the Constitution's qualifications for federal office. The Colorado Supreme Court's decision is no different from a state residency law that requires members of Congress to inhabit the state prior to Election Day, when the Constitution requires only that members of Congress inhabit the state that they represent when elected. In both situations, a state is accelerating the deadline to meet a constitutionally imposed qualification and is thereby violating the holding of term limits. And in this situation,
that's a weird argument to me, going the term limits route.
I'm not sure. I think he must have a different technical definition of term limits. I think he's meaning term constraints.
Right. Yes.
As opposed to how many terms you can serve like we normally think of it. Because he's talking about things like, all right, you can run for a congressional seat in, say, Minnesota, even when you're living in Wisconsin, if you're going to serve your position in Wisconsin.
Right. Yeah, it's a weird thing that he's going after here. I mean, to me, it doesn't apply to the president because the basic logic is he says because the president could be approved by Congress prior to acquiring office, therefore they can't be held off the ballot, which is part of an argument I've made. But the main thing to me is that the president is a manifestation of the political will of the country. When sufficient number of electors are chosen to choose a president, you have decided that the country wants that person. And having some arbitrary process that can be, that is only reserved in the Constitution for impeachment and then subsequent disqualification, having that suddenly applicable just by a state court is insane. The other part of this, on the
practical merits, right?
The other problem I have with this, and I made this argument in a previous live stream, so I won't belabor it too long. But if a state can prevent a president from being on a ballot because they disqualify him from office, then presumably a state can disqualify a president while he's in office, because the 14th Amendment does not prevent a president from running for office or acquiring office. It prevents a president or prevents a person from holding those offices. So if someone were to engage in insurrection, according to a state court in the middle of their term, without a criminal trial, mind you, Colorado could effectively say that Donald Trump is not a legitimate president of the United States. And then we have to ask what that means for the state of Colorado if they do that. Is that in and of itself an insurrection when they choose that? If no other states have done that, it also subverts the power of impeachment, which takes away the entire plenary authority of the House of Representatives and the right to try an impeachment, which is the plenary authority of the Senate, and just gives it to a state court district judge. That's insane. Insane.
And it ties directly into these claims that Trump is making, I think appropriately so, about having immunity from these other charges he's facing in different courts, because I think being elected president puts you on a different realm than other government officials. You're one of the three branches of government now. You're different. You can be impeached, and maybe when you're not president anymore, you can be prosecuted. But I don't think you can be for actions you committed while you were president.
Right.
That's it.
Yeah, it's crazy because there's so many places where the president is literally elevated above any other position. He has to have deferential leeway. He has to make decisions that involve foreign powers. He has to make decisions and be.
Just look at security classification of documents, right? The president is the only person on the face of the earth who can, on a whim, decide that this document is classified or not classified.
Right.
It's a unique power.
And when you think of the
plenary power,
the plenary authority as the president is sole organ of foreign relations, means that the president can enter into what's called an executive agreement with another head of state without it being a treaty, having the full force of law as if it were a treaty, and without the approval of the Senate. If the president can do that, we have to ask if it's even possible for a president to engage in treason by discussing anything with a potentially hostile foreign head of state. Because normally we would say if there's a hostile state and someone discusses something with the government of that state, that they're engaged in potential treason. But can a president commit treason if he is the sole organ, the only authority on foreign relations? He's elevated above every other person in the country for that role. And it's because he's elected, and we have chosen this person to be the face of the people. So
it's an almost king, right? So at the founding, the American people would have been happy to have made George Washington king. He deferred that status. The replacement was president being subject to a Congress. But it's as close to a king as you can get without being a king.
Yeah. And I actually call him a king for 4 years over and over. And if you look at Article 2, Section 1, the first line says, the executive authority is vested in a president and the executive branch. There's Article 2 or Article 1, Section 1, the first line says, the legislative authority as defined herein is vested in a Congress comprised of House of Representatives and a Senate. They had to create the legislative authority. The executive authority was understood at the time to be that of the king, limited by the authority given to the legislative and judicial branches, and those reserved by the states. So it's a unique position. It's new, and it's new, but it's based on old concepts that were understood at the time. We often forget that. Okay, someone, wait, who was it? Jesse Bear says term limits is a court case. Yeah, I was kind of thinking that. I'm not familiar with the court case of term limits. But it might be interesting. He'll probably explain more.
So it's a citation. He was using the phrase as a citation as opposed to the general concept of term limitation.
Right. And he'll probably, as he gets into his argument, say that more or explain more about it. Roger Morgan says, Nick, an AI won't have a threesome, send P videos and get tag teamed by you and a kinky buddy.
I don't know. That new AI, it's looking pretty good.
Look, if you link up the AI with the Dollhouse Phil product, it might just do that for you. Shut Up I Can Cook says, what a treat, Nick and Branca. Let me get some food and booze. Lol. Always a good choice. Cookie. Have at it. Richard O. Team says, you spend thousands of dollars to skip a line and still tell us the story. how someone thought you were a cuck. I spent $20+ you laugh like a jester. Wait, who spent thousands of dollars to skip a line?
I mean, I really don't know. That could have been me. I pay money to skip lines all the time, but I don't
Me
know
too.
exactly what it's.
It's not usually thousands of dollars. I skip lines at the bar by buying the first person in line a drink. He's going like, can I get your drink and then buy mine at the same time? They're like, yeah, hell yeah. And then I make a friend. Indiana the dog says 2 whiskeys in first 2 minutes. Nick asks all the questions for SCOTUS. The questions get good. It moves quickly. Branca, we going to Hawaii strapped or what? You heard Hawaii.
I'm hoping I'll be reading that
second
that crazy Hawaii decision tomorrow morning. If you want to join me, Nick, noon Eastern time.
I don't think I can be there, but I will let you know when I check my schedule. Richard O. Team says, Nick, can we hear one of those great stories of how your wife stepped away for a second and someone thought you were a cuck or a swinger? Branca can probably relate. No, you missed that. What happened? What happened was very simple. When we were at a club and my wife went to the bathroom, because you're not allowed to follow women to the bathroom, even if you're their husband, because they try and protect people. When they come out alone and people see a pretty lady at a club, they try and go talk to her. And so it's not that they think you're a cuck or a swinger. It's that they see a woman. They're like, oh, hey, she's hot. And they go talk to her because that's what people tend to do. And then you smile at them and say, hey, man, what's going on? And they're like, hey, man, I'm sorry. I didn't realize she was your wife. They're like, no, don't worry about it. Peace. Catch you later. And that's that. It's a very simple story. Go out and try it. It's fun. All right, here we go. And then,
so Nick prudently doesn't put pictures of his family up on the internet. But I've met Nick's wife, and she's a very attractive woman.
I mean, yeah, but no, I know. It doesn't matter. Let's just go through this argument. It's so funny because it's like, guys, just go out and meet people. It's okay. It's fine to meet people and have a good time. And you don't have to fight everybody. Beep, beep, I'm a Jeep says, get nose surgery. You sound like a nerd. Real tip. Ooh, let's do that. Richard O. Team says, Nick, this guy is giving me a bunch of money today. Nick, does Branca know about the Mandy thing? Or have you been hiding that too? And yes, Nick has posted his wife's ass pictures. No, she did. And it wasn't her ass, like naked. So chill out, buddy. Here we go. Back to this argument.
Situation. A ruling from this court that affirms the decision below would not only violate term limits, but take away the votes of potentially tens of millions of Americans. I welcome the court's questions.
Mr. Mitchell, would you,
Clarence
you
Thomas.
didn't spend much time on your argument with respect to whether or not Section 3 is self-executing. So would you address that? And in doing that, your argument is that it's not self-executing, but then in that case, what would the role of the state be? Or is it entirely up to Congress to implement?
I love how the Supreme Court can just ask leading questions from the bench.
Yeah. Let me just narrate the answer. I want you to
Could you please talk about these things we'd like you to talk about?
It's this is an interesting question because Article 14th Amendment, Section 3 has a clause that says that Congress will make any necessary legislation to enforce the provisions of the amendment. Some people have argued that the 14th Amendment, and actually some Supreme Court cases have found that parts of the 14th Amendment are self-executing because they're evidently self-executing. They're declaratory statements by Congress in the amendment as it was passed. Other parts require legislation. This one it's interesting to me because Section 3 isn't actually talking about disqualifying someone. It's talking about how someone can be requalified. That would be the only self-executing part because it says that Congress, by 2/3 of a vote of each house, can remove the disability, which would imply that the other part is not self-executing because there's no clause in the document explaining how someone is removed or is disqualified to be requalified. So Congress would have to make legislation on the first part. And the second part is clearly established in the amendment because they didn't want them to make some weaker standard or some bar that is far too high. They wanted to lay that part out, but they figured, well, different circumstances. What is an insurrection here and there? We don't know the context of everything. Maybe Congress should just make laws about it, and then we can figure it out. Really
Makes
simple.
sense.
Clarence Thomas asking him, is it self-executing? The obvious answer here is No, it's not. Thank you, Justice Thomas, for asking that wonderful question. You're so smart. And Pisco is a retard. That's what he should say.
In Section 3?
It is entirely up to Congress, Justice Thomas, and our argument goes beyond actually saying that Section 3 is non-self-executing. We need to say something more than that, because a non-self-executing treaty or a non-self-executing constitutional provision normally can still be enforced by a state if it chooses to enact legislation. The holding of Griffin's case goes beyond even that by saying that a state is not allowed to implement or enforce Section 3 of the 14th Amendment unless and until Congress enacts implementing legislation allowing it to do so. So under Griffin's case, which we believe is correctly decided, the Anderson litigants disagree with us on that point. But if this court were to adhere to the holding of Griffin's case, there would not be any role for the states in enforcing Section 3 unless Congress were to enact a statute that gives them that authority.
Right. That's the difference between self-executing and Congress having the power that's laid out in the amendment. You can create the process by which someone is disqualified through legislation, as it says in the amendment itself. Although I would still suggest that the president would be excluded otherwise from that amendment. But this is a real easy way for the Supreme Court to dodge all of the hard questions and just say, look, if it's not self-executing and Congress has not made a law, then we can't apply it this way. We don't even have to determine if a president is covered by the amendment. We don't have to determine if a state can do this on its own. We don't have to determine any of these questions because it's not self-executing and there's no law that Congress has passed that the state is implementing here. So it's an important way for the Supreme Court to have an easy way out of this argument. Here we go. Shut Up Bike and Cook says, just hi. Very excited to see you two wonderful guys. Hey, thank you. Thank you, Cookie. All right, here we go.
It's always fun to be here.
Back to this.
Counsel,
Also,
what if
thank you to
somebody
Good
came
Logic
into a
and
state
Big Raid.
Secretary of
What's up,
State's
guys?
office and said, I took the oath specified in Section 3. I participated in an insurrection, and I want to be on the ballot. Does the Secretary of State have the authority in that situation to say, no, you're disqualified?
No, the Secretary of State could not do that consistent with term limits.
Correct.
Because even if the candidate is an admitted insurrectionist, Section 3 still allows the candidate to run for office and even win election to office, and then see whether Congress lifts that disability after the election. This happened.
Bam, 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 bam. That's the fight right there.
Yes, but I have to say he mitigated the argument, and I don't like that, because he said that Congress can remove the disability so it can't keep you off the ballot, which is an important question for the ballot part of this, which is the focus of this case. Of course, I understand why he's making it. But in general, the real question is, can this be applied by a state just to a self-admitted insurrectionist? Can that be applied to a president at all? The answer is no. The state cannot disqualify a president even by their own admission, because I can say I'm an insurrectionist and that doesn't make me one, because insurrection is a legal term with a meaning somewhere defined. Even if it's through common law, is defined somewhere. And I cannot just I can't say I'm a murderer and be a murderer. It's an impossible thing to do unless I have actually murdered someone under the legal standard of murder. I don't know if people know this. Technically, you cannot plead guilty to a crime you did not commit. And if you lay a factual basis for the crime you're pleading guilty to, a judge is free to reject it and say that is not actually a murder. The facts that you laid out do not amount to that crime. So just because you declare yourself something, and oftentimes it's accepted, does not mean it's actually true under the legal standard. And how can you just say, I am this, and the Secretary of State go, oh yeah, I'll take your word for it, bro, with no analysis? Because people are often wrong about what they are, legally speaking.
They don't know. They don't know because they don't understand the legalities of it. And by the way, of course, Trump has never declared himself an insurrectionist.
Nor has anyone officially declared him an insurrectionist. Even the court is not.
No one's been charged as an insurrectionist. And
the court has not declared, the Colorado court has not declared him an insurrectionist. They have relied on a congressional report that says that an insurrection occurred and that Donald Trump is somehow supporting it, even though they can't show.
They should just call that the Cuck Report, the Colorado Cuck Report.
Hans 1PK says common law now includes Hawaii law of splinter paddle. Maybe.
I'm going to cover that case tomorrow.
That'll be interesting. Here we go.
In the wake of the 14th Amendment, where Confederate insurrectionists were elected to Congress, and sometimes they obtained a waiver, sometimes they did not, and each house would determine for itself whether to seat that elected insurrectionist, because each house is the sole judge of the qualifications of its members. So if a state banned even an admitted insurrectionist from the ballot, it would be adding to and altering the Constitution's qualifications for office, because under Section 3, the candidate need only qualify during the time the candidate holds the office to which he's been elected. And under Your Honor's hypothetical, the Secretary of State would be demanding, essentially, that the candidate obtain a waiver from Congress earlier than the candidate needs to obtain that waiver.
That's
well,
the
even
term
though it's
limits
pretty
they're talking about.
unlikely, or
Right. And that's a good argument right there, because it's effectively saying someone could acquire office and their disability could be removed. You're asking them to remove the disability before it's even known if they have to. That's not efficient, because Congress could remove a disability for someone who doesn't win an election, and then they've done so for no purpose at all.
Or they could give up, they could sacrifice the disability. So imagine, for example, we lived in a country where you could run for Congress, but you could only take your position in Congress if you were a Democrat or Republican. But you run as a libertarian. You run as a libertarian for election. And then the day you're elected, you say, all right, now I choose my party. I'm a Democrat or Republican. The Constitution says that's fine.
Right. Yeah. And it's a weird thing to require the removal of a disability that may not be necessary. Now, this is different, though, than the constitutional qualifications for president, which are age, natural born citizen requirement, and residency requirements. Those are the only three. And the reason it's different is because those are not subjective claims,
right,
and they are not subject to removal of disability by Congress. There is no vote to make you a natural born citizen that Congress can do. Congress can make a law defining what a natural born citizen is, and then the Supreme Court can decide that Congress has the authority or not under the Constitution to do so, but they cannot make a law that makes one person, or they cannot.
You were born in America.
Right. There's no law that Congress can pass that says this guy's actually 36, homie, so he's good. You can't do that. If you're 27, you can't run for president. Nothing can cure that disability but time. So there is no reason to keep you on the ballot. And that is why those are different from the categorization of an insurrectionist or any other disability that's curable.
at least would be difficult for an individual who says, you know, I am an insurrectionist and I had taken the oath. That would require 2/3 of votes in Congress, right?
Correct.
Well, this is a pretty unlikely scenario.
It may be unlikely, but no Secretary of State is permitted to predict the likelihood of a waiver, because in doing so, they're adding a new qualification to the ability to run for Congress. And
what a great answer.
Analogy, Mr. Chief Justice, is to state residents.
Yeah, I mean, it's like he's prepared for this.
Yeah,
that's why.
In fairness, you're right. He's just doing his job. He should be this prepared in front of the Supreme Court.
And that's why it's important that these, I was talking about this the other day. It's why it's important that these do go through the process, because all of the research and all of the briefing on these very important constitutional questions should occur at the highest levels over and over and over. And these arguments should be refined and refined and refined by the time they get to the Supreme Court. And once they get here, all of the case law should be researched. Any obscure text should be researched. And these guys should be bringing the maximum game that they've got to explain why their argument is right, because this is an issue that does not exist. And so you have to dig into the weeds. You have to find good, synthesis. You have to find good synthesis of cases. You have to find good analogy to get these arguments knocked down.
That's like training for months, a boxer training for months for a fight. You know, you're distilling all the arguments to their perfect form.
Exactly. And yeah, this guy's nailed it. He's doing really well so far.
Residency laws, because the Constitution says that a member of Congress must inhabit the state that he represents when elected. And the lower courts have all held, in reliance on term limits, that a state election official cannot move that deadline any earlier by requiring the candidate for Congress to inhabit the state.
So even if somebody comes in and says, I'm a resident of the Secretary of State's office in Illinois, and says, I'm a resident of Indiana, I have been all my life, I want to run for office in Illinois, the Secretary of State can't say, no, you can't?
Well, the question would be, is that person going to inhabit the state when
the
election is held? So
Yes.
if the candidate makes clear, perhaps through a sworn declaration or through his own statements, that he has no intention of relocating to that state before Election Day, then the Secretary of State would be enforcing an extant constitutional qualification rather than enforcing a new state-imposed qualification. And that's the key under term limits. Is the state in any way altering the criteria for a federal office, either for Congress or for the presidency?
Yes.
And in this situation, the Colorado Supreme Court is going slightly beyond what Section 3 requires, because Section 3, on its face, bans an insurrectionist only from holding office.
Counsel, can I stop you a moment and back?
Is that Kagan?
Yeah, I think so, because
Sounds like her, right?
she doesn't sound as downsy as Sotomayor, and she doesn't sound as it's February.
Don't say it. Don't say it.
Urban as Ketanji Brown Jackson. Azira Box sent 2 super chats. The first one's just blank. The second one says January 6th report did show how Donald J. Trump supported insurrection. No, it didn't.
These are the TDS people.
Look here.
They see whatever they want to see, but no, it didn't.
Azira, here's the problem. They may partially have shown how Donald Trump supported the activities of January 6th. That may be as far as the report went, if you're being generous. But what you cannot say is that January 6th has in any way been an insurrection under the terms that insurrection is understood even today, and much less back in 1866. Remember, the insurrection they're literally referring to is a group of states seceding from the Union, taking out opposing colored uniforms, battle flags, conscripting children to play drums while men marched in lines to shoot muskets at each other and kill each other. That's what they're talking about an insurrection is. Literally,
There's actually shelling of a fort.
the marching of people on fucking other states as if they were a foreign nation was the insurrection they wrote this amendment in the context of. They're not talking about a gaggle of retards going into a Congress building with no guns or weapons, just going, we don't want you guys to vote. Like, this is way different. That is consummate First Amendment activity.
By the standards of the progressive left, they themselves would have been committing insurrection scores of times in the last 10 years.
Yes. And the thing is, January 6th, largely, almost ubiquitously, is a consummate display of protected First Amendment speech and free assembly, with some people who, as outliers, engaged in non-peaceable assembly.
A mostly peaceful riot.
It has been over-prosecuted. It has been over-represented. And there are people, by the way, who are serving multi-year prison sentences who never even entered the Capitol because they sat,
never threatened anybody, never damaged any property.
Restricted area outside of the fence, and just said, stop the steal. We support Donald Trump. This is a fraud. Those are the things they said, and they were punished for their speech and their free, peaceable assembly. And that is actually a shame on the U.S. judicial system, the U.S. political system, the U.S. Congress, and all of those motives. And the real reason is because those ivy-towered elite bitches got scared, shoved their panties into their assholes, and cowered under desks from people who were just saying, hey, this is wrong. And they all pretended they were going to be murdered like Emmett Till that day. And none of them have a fucking scratch on them. None of them. Now, a few people did engage in violent acts against Capitol security, and their prosecutions should be fair, impartial, and if they are guilty of a crime, they should be guilty. But the people who merely shouted, and I would suggest even the people who entered the Capitol building, did not commit a crime unless they commit a subsequent crime. That's my opinion. But here's the funny thing. None of them are charged with insurrection. Even the ones who committed the most
zero.
Even the ones convicted of the most heinous violent acts are not charged or convicted of insurrection. So them saying that Donald J. Trump supported insurrection, it's a phantom insurrection that does not exist, except in the minds of every newscaster hired by.
It's like if you had a bunch of people who were invaded a bank and none of them were charged with bank robbery, and now you want to charge Donald Trump with bank robbery.
Accessory to robbery.
Right.
Hans One Pack says CNN and MSNBC gave up a bit after this SCOTUS arguments. Dude, it's so funny. They've been jocking up the anti-Trump side of this thing. Oh, Colorado court has every right to disqualify him. I've seen so many articles about how he should be disqualified by this thing, and all of them are fucking surprised that, quote unquote, even the liberal justices are like, wait, a state doing this doesn't make any sense.
No, the Colorado Supreme Court is like California left. It's that hard left.
It's because actually they're probably all California transplants.
They probably are.
Yeah. It would be
Listen,
funny.
if you drive around Colorado, like 30% of the license plates are California license plates.
Exactly. PhD Phil 69 says, question, I was born in Brazil and I have a certificate of live birth abroad of a U.S. citizen. Would I be able to run for president even though I was not born on U.S. soil, but to a U.S. citizen? Okay, so here's the weird thing, and this isn't clearly defined. Like, the qualifications are clearly defined in the Constitution.
Objective. Right.
The question, though, is how those qualifications are actually presented and how those qualifications are challenged is still up in the air. So while they are objective qualifications that exist, age ones are really easy to figure out. While they are there, the natural born citizen one is weird because all you do is sign an affidavit that says, I am a natural born citizen of the United States. And you can be born abroad and be a natural born citizen of the United States if you're born on a U.S. military base, for example. If you are spit out of a Muslim woman at Guantanamo, technically you're a natural born U.S. citizen. If you are born of two U.S. parents in a foreign country, you're still a natural born citizen of the United States. So there are these ways, and all you do is represent by affidavit that you are a natural born citizen of the United States. Now, presumably,
then it can be challenged.
Someone with standing would be able to challenge it. The question is, who has standing to challenge that? Maybe another candidate, maybe not, but your average voter, like if I wanted to challenge Barack Obama's legitimacy because I say he's born in Kenya, he's not born of two U.S. parents because his dad was Kenyan and his mom was Hawaiian. Hawaii wasn't incorporated. Whatever you want to make the argument of, all of those theories.
All that crazy stuff.
If you say all of that and they go, who are you to challenge this? And you go, I am a Republican voter. And if Barack Obama is elected, I'm uniquely damaged. They'll say, no, you don't have standing as a voter because you are impacted the same as every other voter. You must be uniquely qualified, which means only someone like Hillary Clinton or maybe Mitt Romney or John McCain could have brought that case against Obama. And of course, they're not going to. But you don't have standing to do so. So how you challenge the legitimacy of a candidate's natural born status when they represent that they are natural born on the form, that's all they have to do. They check the box and they sign the form under oath and boom, they're done. Who's going to charge them with perjury? They're just retarded. They didn't know they weren't natural born. And who is going to challenge the natural born status? Find someone with standing. There's only in those
Elizabeth
cases.
Warren is still a senator, right?
Exactly. Hans One PK says, as long as you do not say 1776 while entering the Capitol. Yeah, well, true. Hans One PK says, in Colorado, everyone has standing to challenge. I don't think
Good
so.
luck.
They actually,
Good luck with that argument.
they're a group of Republican voters. And to be clear, federal standing requirements are a federal imposition. State courts do not have standing requirements typically unless the state individually passes them. So when I talk about standing requirements, I'm talking about federal cases. And when you're talking about a president, generally you're talking about a federal case. The fact that a state court is doing this at all is insane. Bald Eagle says in Colorado, if Colorado can DQ Trump, then Texas can DQ Biden for failure to enforce the law and aiding criminals to illegally entering the country. You would think
in theory, but do we want that to be the law? That's the question.
We do not. L Prince sent a super chat and then a follow-up that says, I really thought a couple were charged with insurrection. Am I wrong? I'm not aware I think some were charged with something akin to insurrection,
No,
but not
the
insurrection
media
specifically.
uses the word insurrection all the time. But when you look at the actual criminal charges, I've not seen one that was charged with insurrection. So you have to be
Because
careful.
you have to ask where they're being charged with insurrection. Typically, you're talking about a federal court, which means a DC criminal court and nowhere else, or maybe a federal criminal court in a different state. You're not talking about state laws don't typically cover insurrection because state laws don't, which is again why it's so weird that Colorado is making a federal crime determination. Remember, Colorado is determining that in Washington, D.C., the District of Columbia, a federal district, that Donald Trump engaged in a federal criminal act without a federal criminal charge or conviction, and where all of the witnesses to the supposed insurrection would be located, and the venue would be proper, the jurisdiction would be proper in the District of Columbia District Court, not in a Colorado state court. This is so highly unusual and batty that
It's so creepy. It's creepy, like in the dating sense. Like there's a hot girl in the chemistry class, and the nerd on the other side of the room is like, "Well, I can just reach out and touch her, and that's okay because because why? That's just no. You can't do that. That's wrong. That's
Right.
one jurisdiction. You're a different jurisdiction. Mind your own business."
Chief Slinging Beef says some of them have been charged with seditious conspiracy. Yeah, that may be true. Seditious conspiracy is, again, not an insurrection. The Constitution's language does not get to be synonymed or supplanted. It was chosen intentionally. Sedition and insurrection are different things. Sedition is subversion of the United States. Insurrection is typically defined as an open armed rebellion against the United
A
States.
completely
way
different government.
Yes. And no one can explain how anyone on January 6th attempted to insurrect the government and
All those
supplant it.
Not
Supplant
one
it with their own.
person.
And my biggest problem with all of this, they say they kept trying to interrupt the peaceful transition of power, which, might I remind everyone, would occur 15 days later without issue or incident. How could people on January 6th, with no supplies, no guns, no organizational structure, and no military hierarchy or uniform or even coherent plan, we're going to take over the capital of the United States, hold it for 15 days to then subvert the peaceful transition of power in favor of Donald Trump? If a subsection of the military that was loyal to Trump had aligned with them, participated, and swept in, maybe you could start to say that an armed insurrection or a coup had occurred. None of that happened, even though some people thought it might. I thought that was ludicrous, but it never did. Hans 1PK says, this is a case today at SCOTUS. Colorado allows to challenge if eligibility to run for office. Sort of, but can they? Whether they do or not is completely irrespective of if they can. Please remember there are tons of laws on the books that are not constitutionally enforceable. Some states still have laws that whites cannot marry blacks, even though Loving versus Virginia in 1962 has made all of those laws unenforceable. They still exist. That's the law in several southern states. No whites can marry blacks. Loving versus Virginia supplanted those. Some states still had laws that banned abortions, even though Roe versus Wade existed and said they couldn't happen. Once Roe versus Wade were overturned, those laws were automatically implemented because Roe versus Wade was no longer a barrier to their enforcement. Enforceability and existence are two different things. Nick Miller says many of the judges are members of the Asian Pacific American Bar Association of Colorado for some reason. So there you go. Here, back. I don't know either, but back to the, I like it though, but back to this.
Minute, you admitted that the concept of self-executing does generally permit states to provide a cause of action for breaches of a constitutional provision.
Correct.
In fact, they do it frequently for takings clauses. There's no debate that Colorado has placed
She sounds
that,
drunk.
provided that cause of action. You want to go.
So this is interesting because it's Elena Kagan, who, for the record, of the three liberal justices, Kagan was only appointed to pass Obamacare. She actually was an appellate court judge that ruled on Obamacare. She was brought into the the Supreme Court to rule on Obamacare. She did not recuse herself. But all of that said, that's why she was brought in. Kagan is actually by far of the three, the most reasonable of the three. Sotomayor is
her 100%. She's the one who's not an idiot.
Sotomayor is a walking used condom. She's the dumbest person in the room. Ketanji Brown Jackson is an admitted diversity hire by Joe Biden. Here's what he said.
By her own admission, she was asked, what is a woman? She's a woman. And she said, I'm not a doctor.
Jesse Lee Peterson, on my interview with him, laid out exactly what Biden was looking for when he when he nominated her. Here it is.
I just need you to be black and a female.
That's exactly what he said. That's exactly who we were talking about. And he nailed it. And Biden said that in a speech. Look, I was looking for a black female justice, and I picked the one that looked like all the others.
That had an exotic African name.
Yeah, the most African name possible.
And American name, Ketanji Jackson. Perfect. What more could you ask for?
I wish it was Ketanji Jackson Brown instead of Brown Jackson. Hans One Pack says, why do you think they selected Colorado to challenge Trump? Colorado gave individual right to challenge. Yeah, I know.
Colorado's become so hyper liberal in the last 5 years. It was a fertile ground for this kind of thing.
But again, please listen to me right now. You can pass a law all day, and until that law is constitutionally challenged and then ruled on, it is presumably enforceable. Let me say this, the Judiciary Act itself, which limits the Supreme Court to 9 justices, is likely unenforceable and unconstitutional, but no one has actually chosen to challenge that. FDR threatened it. Biden has implicitly threatened it. After this case, we may see the requisite political will to threaten it if the Democrats can get enough senators to appoint a new Supreme Court justice. If they can get enough of a majority and Biden can appoint or nominate them and they can confirm that justice, he may nominate a couple more to outdo the conservative majority on the court. But the Judiciary Act is a law that restricts the Supreme Court to 9 justices. Tell me in the Constitution where the 9 justices touched you. It doesn't say Congress does not get to define the Supreme Court in any way. They only get to define every court below the Supreme Court.
Correct.
Congress, I think their only limitation, or the only thing they can do to the Supreme Court, is limit the Supreme Court's original jurisdiction by legislation, I think. Other than that, they have to pass a constitutional amendment to do so. Or no, sorry, not their original jurisdiction. Congress can limit the Supreme Court's appellate jurisdiction by statute because of the Constitution. They cannot limit their original jurisdiction. They cannot limit the makeup of the court. They have no authority over it. They get to make every lower court. Congress gets to determine those.
It's an independent branch of government. Independent branch of government.
Yes. It's very, very critical to realize that. Okay, we're going to play a little bit more. We'll flip to Rumble. There's no way we're getting through this whole thing tonight, guys, because I'm not going to go 17 hours. We're talking too much.
Sorry, Nick. I feel bad. Nick and I talked about this beforehand. We're like, dude, it's like 2 hours of Supreme Court stuff. Let's just burn right through it.
How far do you think we've gone?
Obviously, we're like 20 minutes.
7 minutes and 22 seconds in.
Gosh.
So bad. We're not going to get through this tonight. We know we're going to go through some of it. I will continue on the quest to do this later. If Branca can join me, he's welcome to. If he can't, that's okay. We'll keep going. But here we go. Hans 1PK says Colorado gave them standing. Again, states don't have standing requirements. That's what I'm telling you. This is state law. If we wanted to challenge Obama, this would be the state to do it in. All other states, they were kicked on standing, except Maine. Right? Except Maine. Federal standing requirements exist. States don't have standing requirements. We've talked about this. You don't have to keep justifying it. You don't have to do that. Here we go.
Go a step further and say that this, like the treaty clause, requires implementing legislation to permit the state to disqualify an insurrectionist.
That's correct. So
under Section 3.
That's right.
So history proves a lot to me and to my colleagues generally.
History proves
there's a whole lot of examples of states relying on Section 3 to disqualify insurrectionists
Yep.
for state offices.
Right.
And you're basically telling us that you want us to go 2 steps further. You want to
Right.
maybe 3.
Federal offices.
You want us to say
and
that
then
self-execution doesn't mean what it generally means. You want us now to say it means that Congress must permit states or require states to stop insurrectionists from taking state office. And so this is a complete preemption in a way that's very rare, isn't it?
Well,
No. So remember that this is Kagan, and her job here is to challenge and limit the scope of this guy's argument. So
Right.
she's not actually even talking about Donald Trump right now. She's talking about the maximum level of his argument that says that Congress can limit the state's authority over state elections, the state's authority over federal elections within the state, and the state's authority over presidential and vice presidential elections. She's saying, is that true? This guy's going to say, yeah, that's what it says.
So his
Because-
argument is basically like if we were talking about like a high school election to senior president, that the junior high school gets to tell the high school who they can elect as president.
And the answer is, in this case, no. The senior high school gets to define a law in which the junior high school might be able to do that. But in no other circumstances do they have the authority to limit who gets to hold office, because it says so in the text. All right, here's what we got to do, guys. CBDistillery.com is our first sponsor of the night.
Awesome.
CBDistillery.com, promo code NOSE. Guys, this is CBD products. No fluff, which means no blowjob for you. No fillers, which means no love for you, ladies. Just pure, effective cannabinoid products. Look, they sell 2 things: CBD products and Delta 9 THC products where they're available. That's the traditional marijuana stuff. They sell them in gummies. They sell them in, I think, vapes. They sell them in creams that you can rub on your body erotically. But look, I don't have much to say other than this. Promo code NOSE gets you 20% off. If you have a health issue that you have tried some other medications and it's just not happening, you need some relief from pain, you need relief from anxiety, you need relief from nausea, stress, you need increased blood flow. CBD products have been shown to do this. They're not FDA approved to do this because the FDA hates Black people and Mexicans. So they don't like marijuana generally, but they have been shown in studies to do these things. People have reported success in doing these things. CBDistillery.com, promo code NOSE. They can help you with these issues. My favorite product that I have tried of theirs is the Sleep Synergy Gummy. It is a CBD, non-THC product. You eat the gummies, they make you fucking tired within about 30 minutes. And they're really, really good at it. They taste like assholes. Trust me, they're gross, but they work really well. And the taste goes away, especially if you chase them with whiskey. They'll make you tired. You'll want to go to sleep. Use promo code NOSE. Get some money off. I could read you their script, but do you want me to do that? Their script is going to be gay. You know it's going to be bad. It's going to be some marketing guy being like, wow, I tried CBD Distillery and I got a boner that lasted 8 minutes. No, you just listen to me. I tried the sleep ones. They're great. They have this rub-on stick for topical pain relief. It works. It's nice. I don't know why. It's like Tylenol. I don't know how that shit works either, but it feels good. It works. Maybe it's psychosomatic. I don't care. They're nice. They're great. They sponsor the show. They believe in free speech. I could say, look, if you rub the stick on a Jew, the Jew goes away. And they don't care because they smoke. That doesn't actually happen. Trust me, I've tried. I rubbed one on Ben.
Poor Joe Neerman right now. It's like,
No, I rubbed one on Ben. I would never get rid of Joe Neerman, but I took the pain relief stick and I rubbed it on Ben Shapiro. Abby Shapiro showed up with deflated tits, and I was like, why is this thing happening? No, look, they're a great company. I love them. They support the show. They support free speech. They support people with our opinions and other opinions because they just don't give a shit. They just want to sell you good stuff. Go to their website, cbdistillery.com. Check out the benefits that they have. If a condition that you are suffering from fits in there, maybe this is a good fit. Use promo code NOSE, get a discount. Help yourself out. Try it out. If it works, buy more. Buy a shitload of it. If it doesn't work, don't buy it ever again. It's amazing how capitalism works. cbdistillery.com, great supporter of the show. Check them out. Thank you guys for sponsoring. All right, guys, we are going to flip to Rumble. 25 seconds for that. And then I'm going to step away for just a minute to go to the bathroom. I'm going to let Andrew Branca talk about lawofselfdefense.com/free book or whatever else he wants while I go check on Lady Rackets and go to the bathroom. Go to Rumble. It's in the pinned comment. It's in the pinned comment. It's in the description on YouTube. Click on it, motherfuckers.